Hello, good morning and welcome to further Ekulo analysis. I am reporting from Enugu. My name is Emeka Ogwonye and I'm in the city of Enugu, just arrived this morning. And one of the things we intended to explore in this visit is how the story of Senator Ekwere arrest in the United Kingdom is being taken by the people of the city. Right from the airport, when we got into the aircraft flying to Enugu, the major story on the lips of everybody was the story of Ekweremadu. People are still shocked particularly in this part of the country. This is the city of Ekweremadu, the city of Enugu. He is a popular senator here, a prominent politician here. His name recognition is second to none in the city and state of Enugu. Everybody here knows Ekweremadu. You can't meet two people without running into someone who would say he has met with the senator, he had known the senator, and a whole lot of people here sympathize with him. But the story of his arrest and continued detention in the United Kingdom remains a tragic story, remains something that many people are worried about, especially looking at the details of the story. His daughter is sick. His daughter needs help. Help was almost found. In the process of the search for help for his daughter, Senator Ekweremadu and his wife got arrested in the United Kingdom, charged to court in the United Kingdom, and denied bail. Presently, they are in prison custody in UK. It is a tragedy of extreme proportions, and the people of Enugu are taking it that way. As we discuss this case, invariably, we will have to explore the issues that are involved. Many people have said that the critical question is going to be the age of the organ donor, the potential organ donor, or the failed organ donor, the young man taken from Nigeria to the United Kingdom with intention for him to donate his kidney, which would then be transplanted into Ekweremadu's sick child to heal her. So the question central to it all had been the age of the young man. The British authority initially stated he was 15 years old. And if 15, he will be a minor. And if a minor, then he cannot consent to anything. If a minor, then there is a serious, serious crime on the way. And that is the thinking of the British authority. But information coming after that had shown that the child is actually more than 15 years old. They're saying he is 21. If he is 21, it changes the dynamics. And of course, if he is 21, it changes the dynamics of the whole matter. However, the age of the young man is not decisive. The legal issues involved in the case of Ekweremadu, to the extent we know it now, cannot be resolved entirely by the issue of age. If you look at that law, the law against human trafficking, the law against taking undue advantage, exploitation of human beings, and especially in the context of organ harvesting, the laws involved, the issues involved go beyond the age of the child. Okay, let us say that this young man is 21. Let's say his information given to the embassy, the immigration authority in Nigeria, that led to the issuance of his visa that recognized his age as 21. Let us say that is all correct. Let us say he was adequately and correctly represented at the Office of Nigerian Immigration and that his age is 21. Let us say that's the case. Now, the problem is going to be the details of the arrangement between Ekweremadu and the young man. Who procured the young man? Who identified the young man as a suitable organ donor? What sort of agreement was reached between him and Ekweremadu? Because on the issue of human trafficking, deception or fraud or dishonesty or misrepresentation could be a factor. Was he paid? That could be a factor. How much was he paid? What was he promised? So these are the things. When you are getting a person for the purpose of organ donation, you probably should go through a credible agency to ensure that nobody, the child is not going to turn around and say that he was coerced or there was undue influence, there was fundamental misrepresentation that led to his agreement to donate organ. We don't know these details, and we think that is where the problem would lie. The young man going to UK to give his kidney, there must have been arrangements, promises made to him that if you give your kidney, we're going to keep you in the UK, we're going to register you in the school, because removing a kidney is not a joke. It involves a major surgery. So the young man would have been expected to stay in the United Kingdom for some time to recuperate. Probably he was promised he would go to school. Probably he was promised he was going to live in the United Kingdom. Now, we don't know these things. We are just guessing it. So, assuming the young man got to United Kingdom and it was discovered that the organ was a mismatch, that his organ could not be taken. In other words, he was no longer a suitable candidate for organ donation, assuming that was the case. If that was the case, what do you think would happen in the normal course of human engagement? We believe that when it was discovered that the young man's kidney was not suitable, the Ekweremadus would have come back to him to say, well, it failed. The transaction has failed. You need to return to Nigeria. If we promised you scholarship, we can't give it to you because it failed. Or if we promise to settle you in United Kingdom, we can't do it anymore because it failed. Now you come and go home. So at the point, what do you expect the young man to do? He came to United Kingdom under certain arrangement. That arrangement did not provide for the possibility that his kidney would not match. It probably did not provide for the contingencies of what would happen if your organ doesn't match. So, the fact that the organ did not match would have been a disappointment, not just for the Ekweremadus, it would also have been a disappointment for the young man. So, the agreement between these parties probably left the issue of what would happen if the organ did not match. It left it out. So when that happened, the parties were thrown into a territory or a situation they did not prepare for. And the Ekweremadus would have said, okay, return to Nigeria. And the young man would have said, no, even though it did not match, I want to receive all the benefits and promises I was made in Nigeria. So now you can explore the issue of why was this detail not captured in the agreement. But that takes you back to the issue of the contracting process. What sort of contracting process occurred between this young man and the extremely influential and powerful figure such as Ekweremadu? Did the young man have a lawyer? Did anybody negotiate for him? Or did the Ekweremadus just walk up to him and discuss with him? If the contract was strictly between Ekweremadu and the young man, it is fair to assume that the negotiating parties of the powers of these parties are not equal. It is possible to assume that the young man felt misled, deceived, or he found himself in a situation that was not prepared for, and he had to respond to it in the way he perceived to be his best interest, leading to the crisis we have. So, one thing you must know, whichever way you look at it, is the British police, the Metropolitan Police, responsible for the arrest of Ekweremadu, must have investigated this case. They don't normally arrest people without reasonable suspicion that a crime was underway, which would have involved a long investigative process. Then, there was also the decision to charge him. As you know, in United Kingdom, the decision to arrest is made by the police. The decision to charge is made by the prosecutor, lawyers. So there were two decisions made in the case of Ekweremadu. The decision to arrest and the decision that there was a prima facie case to indict him and prosecute him. And now the judge, the magistrate, has made a third decision. The first judicial decision has been made by the magistrate. And that decision was the pre-trial detention of the Ekweremadus. Should they be granted bail pending the case, or should they be remanded pending the case? The magistrate had made a call, and his call was that Ekweremadus should be remanded. So, when a judge denies you bail, a number of factors are at play. First, the judge is looking at the gravity of the offenses charged. The judge is looking at the evidence presented so far, what you may call proof of evidence in the Nigerian criminal trial. The judge must have looked at it, consider the gravity of the offense, consider the likelihood of conviction, and then consider other factors such as the capacity of the suspect or the accused person to interfere with investigation or influence witnesses or intimidate witnesses. So these three decisions have been made: decision to arrest, decision to indict, and decision to deny bail. All three decisions were against Ekweremadu. It is wrong, insofar as we sympathize with Ekweremadu, insofar as we must support him on moral grounds, insofar as we identify with the pains of a parent trying to save a sick child. When it comes to the legal question, we must not rush. The issue of the letter that Ekweremadu wrote to the embassy does not answer any of the critical questions. Indeed, looking at it from a strict legal balance, that letter could actually have been well calculated to create a facade, to create an impression that he complied with all the processes and procedure. And by the way, applying for visa is a different thing. The British High Commission basically had to determine whether Ekweremadu would be able to come back to Nigeria, whether they could give him a visa, whether the young man being sent to the United Kingdom can come back, whether the sponsor has the capacity to do so, and they approved it. The fact that the British High Commission granted visa does not in itself suggest that the British authority approved every detail in the negotiation or the processes involving donation of organ by that particular person. Indeed, if you know law enforcement very well, it is totally possible that the British would have granted that visa to determine what was the intention of Ekweremadu. So we don't know what really led to what, but it is wrong to look at all these things being said on social media, the letter of Ekweremadu, and the passport of the young man, and conclude that Ekweremadu has no case to answer. Apparently, he does have a serious challenge, and in the coming days, we will know more. And certainly on the 7th of July, when the case appears in court, when the case opens in court and Ekweremadu and his wife appear in court, we will get to know better. On the issue of his detention, as of now, he is going to remain detained until the 7th of July. But it doesn't end there. It is totally possible that Ekweremadu would have hired very high-powered lawyers in the United Kingdom who could go back to the magistrate, file an application requesting immediate release of Ekweremadu even before the 7th of July. However, we expect that bail will eventually be granted and he will be out. Whether he will be allowed to return to Nigeria immediately while the case is pending is something we don't know. Now, another question we can ask is whether there will be some level of diplomatic intervention on behalf of Ekweremadu. I believe that Ekweremadu is in good books of Nigerian government. They are going to make efforts to accord him the best consular protection possible, and also even go as far as approaching the United Kingdom government, requesting some soft ground, requesting some accommodation. It is possible. All these things are possible. Specifically, the British Attorney General can actually intervene. Absolutely. Just like we have in Nigeria. The Attorney General of the United Kingdom can actually intervene and stop this trial I don't know what factors will inform that, but it is a possibility at this time. Thank you and stay tuned. We will bring you further updates on the case of Ekweremadu. All right.